Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. First, we want to wish all the moms out there a happy Mother's Day. And yes, we have a weekly recap for all of the top stories of May 12th, 2024, all located in one convenient location. We hope you enjoy it. And hey, happy Mother's Day.
All right, lawyer.
First on the docket, more secrecy in the Brian Kohberger matter. So the court has issued some more orders, and I like to read the orders. Therefore, you just can't say, oh, that's open to interpretation, anything along those lines. So here's what's happening. The court has, for the reasons articulated in the record during the May 2nd, 2024 hearing, the court orders the hearing on the defendant's fourth and fifth motions to compel, which is now set for May 14th of 2024, be sealed to protect the parties' right to a fair trial. Now, during the hearing, it is anticipated that the parties will discuss specific items of discovery that may not be admissible at trial. The disclosure of such evidence to the public at this stage of the case is not appropriate and may prejudice the jury pool. Furthermore, the parties have stipulated that all attachments to the discovery requests and responses be filed under seal, pursuant to various rules and statutes, and because the documents contain facts or statements that might threaten or endanger the life or safety of individuals. It is necessary to preserve the right to a fair trial, and disclosure would constitute an unwarranted invasion of personal privacy. So the hearing on May 14th, 2024 will deal directly with attachments to sealed discovery requests and responses. And if issues arise that should not be sealed and should be addressed at the public hearing, the court will hold a separate open hearing at future dates to ensure that the victims' families have prior notice to be present at any open hearing. Now, the hearing on May 14th, 2024 will not at any time be open to the public to ensure the victims' families are afforded every right under Article 1, Section 22 of the Idaho Constitution. Why such secrecy, ladies and gentlemen? I'm telling you, I've been doing this for 29 years. I cannot think of a single case, and I've handled some very high-profile cases in my career where the media was there, a lot of media attention. Not once did anyone think of closing the proceedings. I understand some people read the Sixth Amendment as a right to an open public trial, only mean the trial. And there's some case law that would indicate as such, and certainly in Idaho they've come up with this rule that, if we can close the case for any reason whatsoever, let's go ahead and seal it. We saw the Chad Daybell, Lori Vallow pretrial matters were all basically done in secrecy. And I'm telling you, I've never seen anything like it before in my life. I cannot imagine where we would go in behind chambers or kick everybody out of the courtroom and conduct a motions hearings. And motions hearings are to determine what evidence is going to come in at trial. So here the judge is saying, well, there may be evidence that may not be admissible at trial, so therefore we don't want the public to know. That's the whole purpose of motions hearings, ladies and gentlemen, to determine legally if various evidence will come in or will be prohibited. So what does it matter if the public knows about it? The jury pool. We've seen it in every case. The Chad Daybell trial there in Idaho going on right now. People are aware of the case, but they're willing to disregard what they've heard and follow the instructions. That is what matters, not what is admissible or inadmissible. I get it, Idaho. It's your state. You can do what you want. I've practiced in Colorado. I've practiced in federal military courts. I've practiced in federal courts in South Carolina, North Carolina, Wyoming, South Dakota, Oklahoma, New Mexico, if I didn't mention that one. Never once we have a secret hearing. And we're talking about some serious stuff that was embarrassing to people. And no one thought that they should go into chambers. So hopefully Idaho gets around to maybe possibly changing their rules. The only time I've ever seen a closed hearing is if for some reason a child a case involving a minor, usually like terminating a parental rights, so they kick everybody out of the hearing. But that's a civil matter. That's a civil matter. That's not a criminal matter. Unbelievable to me. But the court also issued some other orders, and since the government got burned last time they had a hearing, as you may recall, there was a whole issue as it relates to whether the experts for the defense should be allowed to continue their survey. The prosecution was completely unprepared, but the judge said, let's have a hearing. The defense showed up with their expert and said, let's go. And like I said, the prosecution looked terrible, completely unprepared. And if anybody watched that entire video, there's only one way that you conclude, is that they were totally unprepared. And ultimately, the defense won that particular issue. So this time, the prosecution asked for, and the judge has ordered, that obviously the case has been set for hearing. And since the prosecution was unprepared, the court has said that based upon the May 2nd, 2024 hearing, the court orders any of the following: any witnesses, including experts, expert reports, if any, summaries of what each witness is expected to testify to, and exhibits the defense intends to present at the May 14th, 2024 hearing or the May 16th, 2024 hearing on the defendant's fourth and fifth motion to compel, must be disclosed to the state and filed with the court no later than May 7th of 2024. Yes, ladies and gentlemen, that's because the prosecution got slapped around and looked silly the last time. So the prosecution said, we want everything beforehand. And I get it. That's basically the way the rules are set up. But so often, what has now become, everything's turned into civil litigation in criminal law. Criminal law used to be, man, let's go to trial. Let's have a motions hearing. Let's do it. Hey, you got my guy's report? Let's go. Boom. Now everybody wants everything beforehand. It used to be just go out there and let's have a hearing. And sometimes you did great. Sometimes you didn't. But everything these days is turned into a civil case where everybody wants everything and everybody wants to take a deposition and blah, blah, blah. It's just getting ridiculous. Just go try it. Go do what trial attorneys are supposed to do and go to court, think on your feet, and be prepared for anything. That's what attorneys get paid to do. That's right. The defense blinked. Remember I talked about this just the other day where I said it's going to be very unlikely that all this pretrial motions work is going to get done in time. And then the judge in the case, Judge Francis C. Gull, was saying that, hey, we've got 2 weeks blocked out. That's all I was told about. Prosecution has 100 witnesses. The defense says they have 72 witnesses. No way were they going to get that done in 2 weeks. Simply was not going to happen. And I said this is kind of a little cat and mouse game. The question is who's going to blink first, the judge or the attorneys for Richard Allen? Well, guess what? It was the attorneys for Richard Allen. So the case has been delayed now until mid-October when it was originally set. Now, obviously, if you've been following this case, Allen faces 4 counts of murder in regards to the February 2017 deaths of Abby William and Libby German near the Monon High Bridge there in Delphi, Indiana. Well, at a hearing on Tuesday, the special judge, Francis C. Gull, granted the request of the defense to vacate a May 13th trial date. So the attorneys, Andrew Baldwin and Bradley Rossi, had previously requested a speedy trial. In fact, they demanded it. They wanted the case dismissed for violation of speedy trial rights. So guess what? That issue, poof, gone on any appeal if and when Mr. Allen is convicted. So those proceedings are now going to go begin in October, but they're going to use their efficient time. So the trial is now scheduled for a month, but there's going to use the time in May, specifically May 21 through 23rd, for pretrial motions issues. Now, Allen's defense attorneys had claimed that they had not had enough time to properly prepare their case and that the court had not granted the defense enough time to present their case during trial. As you may recall, the judge sent out an email to the prosecutor and the defense attorney saying, hey, I've looked at all of this alternate suspect evidence. And yeah, I don't think it comes in. And oh, by the way, we have 2 weeks set. You didn't tell me. So the judge kind of called the bluff of the attorneys. And like I said, they blinked. So the defense attorneys were worried that the prosecution, that has more than 100 witnesses, would dominate all of the proceedings, and the time was allotted, and the defense indicated they wouldn't have time to present their case because the defense has 71 witnesses they intend to call. Now, obviously, that will get pared down prior to trial, but that was the excuse they needed to get the continuance. Now, Mr. Baldwin and Rozzi wrote in their motion for the pretrial hearing that the logistical challenges for the trial, including an out-of-town jury, Mr. Allen's daily transportation to and from the prison where he is being held, would throw off the judge's aggressive timeline of only 2 weeks. Additionally, the state filed a motion in limine last week asking the court to bar the defense from presenting its alternate murder theory, the alternate suspect theories, that members of a local pagan group killed the girls in a ritualistic fashion during the proceedings. Now, the prosecution filed that motion after the judge said, hey, I don't think I'm going to allow this in. Hint, hint, wink, wink, nudge, nudge. Say no more, say no more. Mr. Prosecutor, how come you haven't filed this motion? Anyway, the prosecution says it's going to cause too much confusion and prejudice to the jury. They won't be able to figure out because juries are just a bunch of nincompoops, according to the prosecution. Anyway, the prosecution also sought to bar the defense from mentioning any cult or ritualistic killing or any other terms from the trial, as well as the names of several people previously linked to the case in one way or another. The defense also filed another motion to have Judge Gull disqualify herself from the case. And during a somewhat contentious hearing, Judge Gull told Mr. Rozzi that she couldn't understand why Allen's team couldn't defend their client during the time allotted for the trial. Mr. Rozzi argued that you don't know anything about this case, citing a lack of pretrial hearings to debate potential evidence. The defense previously asked the Supreme Court to remove Judge Gull, which the High Court declined to do so, and they filed an earlier motion asking for the judge to recuse herself as well. She also refused to do so. Now, Judge Gull attempted to remove Baldwin and Rozzi from the case early on, citing that they had leaked this evidence and expressed concerns about their ability to defend Mr. Allen in such a complex case, which apparently now is just so simple. But the Indiana Supreme Court reinstated the attorneys back on January 18th. Now, the prosecutor, Nick McClellan, asked the court to hold Baldwin and Rozzi in contempt, citing that they had leaked this evidence and sent out information in violation of a gag order. But Judge Gull said, although they were sloppy and incompetent in the handling of the evidence, it kind of fell short of being willful and intentional, so she didn't do that. And oh, that's right, all those comments were made before the gag order went into effect, so there was no violation. You would think anybody with first-year law school experience would be able to figure that out. Apparently, the prosecutor couldn't in this particular case. And the defense has also accused prosecutors for failing to turn over discovery in a timely manner. The attorneys are accusing investigators of lying or omitting information in order to implicate their client. So we knew things were going to get heated. I hope they get more heated, and maybe we'll even be able to see or hear the motions hearings to see why the judge believes the alternate suspect theory shouldn't be allowed. The alternate suspect theory is a little different because, remember, the prosecution has to prove identity. They have to prove that it was Mr. Allen that killed those 2 young girls, not someone looked like him, not someone using his identity, but it was in fact him. And normally to bring in alternate theory suspects, you have to say, hey, these people over here did this crime, paganists, things like that, Odinists, and they were in the area and basically kind of fits their MO. So I believe the court will be somewhat correct as it relates to maybe not bringing in evidence of accusing specific people of a crime. However, it should be completely ripe for cross-examination as to the investigation and the extent to which the prosecutors either followed up on the whole Odinistic thing or they dismissed it. That is where the defense is going to make their hay, so to speak, when it comes to that. All right, we'll be watching, but a little disappointed in the defense, not going to deny it. They demanded speedy trial. And by God, if you're going to jump up and down, demand speedy trial, you better be ready to go. But I understand they have a bigger duty to their client, which is disappointing that we're not going to have a trial here starting in just a week or so. Next, things got a little stormy in New York yesterday. We brought you some of the story yesterday, but definitely a little more to discuss. We mentioned yesterday the judge allowed Miss Daniels to get into great detail as to the sexual exploits that she alleges took place between herself, the former porn star, and the former president. The judge, over objection, let her describe how Mr. Trump apparently came out in pajamas and told him to go change, and then maybe spanked him with a magazine where he was on the cover of it. And then they got into whether it was unprotected sex or not unprotected sex. And of course, the defense was objecting. And then the judge was like, why weren't you objecting? And the defense said, we did, Judge. You just allowed it. But then the judge, realizing that, ooh, my goodness, maybe I allowed just a little too much evidence in, told the prosecution, hey, let's tone it down a bit. This is a family program. Well, not really, because the judge didn't allow it to be televised. Anyway, on cross-examination, Ms. Daniels basically told the world that she hates Donald Trump. She'll never pay him. But where things got really tricky, and this has got like mistrial written all over it, at least at the appellate court level, I don't know. Maybe the judge in the Stormy Daniels case, where Donald Trump is charged with falsifying business records, and the judge allowed in all this risque stuff about a sexual encounter. How does that go to prove or disprove the crime of an accounting issue in a falsification of documents case? It doesn't. Judge, have you ever heard of that guy named Harvey Weinstein, former movie mogul? Yeah, that's right. And that was a sex assault case. And the Supreme Court said, you can't do that. Ridiculous. Somebody should just declare a mistrial now, put everyone out of our misery. I watched a lot of this information yesterday throughout the spectrum of commentators, those from the far left to the far right. And one thing is clear. Even the far left people said that Miss Daniels was a terrible witness. It probably should have been a mistrial. And the prosecution should be losing this case. We'll see if the jury bites at this evidence or not. Wait and see. More to come, no doubt. Next on the docket, more information as it relates to the Lakan Riley matter. A formal indictment in the Lakan Riley matter has been handed down, and the man accused of killing the nursing student while she was out jogging on a trail at the University of Georgia earlier this year has been officially indicted on 10 charges. Now, one of those charges stems from a completely separate peeping Tom incident. Just so we're clear, the guy was looking through somebody's windows, trying to see something that somebody probably didn't want him to take a look at. Yes, that is sex offender registry type of stuff. So this apparently, this peeping Tom incident allegedly involved a University of Georgia staff member earlier in the day. Now, as you may recall, Lakan Riley, who is only 22, and a nursing student, was found beaten to death on February 22nd. An immigrant by the name of Jose Ibarra was arrested and charged with her murder. Now, Ibarra is now also charged with peeping on the University of Georgia staff member, and the indictment accuses him of going to an apartment at the University Village Housing Building S, and peeping through the window at the woman on the same day he is accused of killing Miss Riley. The indictment did not indicate if the peeping Tom incident took place before Miss Riley was killed, but one's probably going to assume it did. I'm just thinking, this guy's looking through the windows. He's getting all this pent-up energy, can't take it out. So what does he do? He sees Lakan Riley and does what he does. Anyway, the indictment also charged Ibarra with asphyxiating Riley, along with inflicting blunt force trauma to her head. Now, Mr. Ibarra was initially charged with 7 counts: malice murder, felony murder, aggravated battery, aggravated assault, false imprisonment, kidnapping, hindering a 911 call, and concealing the death of another. The new indictment adds 3 charges, included aggravated assault with attempt to rape, tampering with evidence, and the peeping Tom charge. Now, the tampering with the evidence charge accuses him of hiding a jacket and gloves in an attempt to keep him from getting caught. Bad case. Not a whodunit, that's for sure. We'll give everybody the presumption of innocence, but that's one of those cases that was preventable because, as you may recall, that gentleman was in custody in New York on a felony case, but got released. Next, we have an update on the airman that was shot by the police the other day in Florida. All right, so now the body cam footage shows just the moments leading up to the United States Air Force Senior Airman Roger Fortson, who was only 23, that got killed last Friday. Now, a neighbor describes a disturbance to the officers as she leads the officer through the apartment complex. She tells the officer that she believed that a fight had maybe gotten out of hand in one of the apartments, and she said that she heard somebody getting slapped. When asked what room the alleged fight took place, the woman responded 1401. Now, the officer then confirmed with the woman that she was going to the 4th floor before riding up the elevator to Fortson's off-base residence at this apartment complex there in Okaloosa County, Florida. Upon arriving at the floor, the officer knocked once and then again saying sheriff's office, opened the door twice. As the door opened, the sheriffs ordered step back and do not move. The officer then fired 6 rapid shots that sent the 23-year-old stumbling to the ground. Now, the woman or a friend that Mr. Fortson was FaceTiming at the time claimed that Fortson heard a knock at the door and asked who it was there. And according to that witness, when he did not receive a response but heard another very aggressive knock, Fortson peered through the peephole but did not see anyone and grew concerned. Out of concern, Mr. Fortson retrieved a firearm, which he was legally permitted to have. And then when he returned to his living room, the police pushed through the door and shot him 6 times. Now, the deputy involved in the incident has been placed on administrative leave, which is rather normal in a situation where there's an officer involved shooting. Now, Senior Airman Forsman, was stationed at the Special Operations Wing at the Hurlburt Field there in Florida and has been on active duty since November of 2019. Now, there was some information, and we reported this, and if we get it wrong, we're going to update it, we're going to fix it. But there was some information that somehow the police officers went to the wrong location. Nope, not the case at all. And then, as you can see very quickly from the video, the door opens, the officer says stop, and shots are fired. You let me know if you thought Mr. Fortson did something wrong. I didn't see him point the weapon at anybody, but officers had to react there very quickly. I don't think it was a racial thing. I think maybe the officer, maybe he was quick, maybe he did everything appropriately. We're going to have to wait and see what comes of it. Either way, I'm sure the city will wind up paying Mr. Fortson's family some money, but we'll wait and see.